Hello, and welcome back to the Interesting Lawyers Podcast. Today's guest is an old friend and a real specialist lawyer, Fred Cunningham. Fred, good morning.
Good morning, Russell.
By way of background, Fred is a negligence lawyer for the most part, but his real specialty is known as bad faith. And for our listeners who may not be aware of what bad faith is, I'll keep it simple. Basically, people buy insurance for all sorts of things. When there's a claim, guess what happens? The insurance company doesn't want to pay, or they don't want to pay what the claim is worth. And lawyers run into that all the time. And it's always a big question, is the carrier going to pay? Is the carrier not going to pay? They have an obligation to act in good faith in handling claims, and when they don't, that's called bad faith. And that's why Fred is really a lawyer's lawyer. He's the lawyer who lawyers call when the insurance company screws up and doesn't pay the claim or doesn't pay what they're supposed to claim or what they're supposed to pay. Fred, how am I doing so far?
You're doing great, Russell.
And the consequence of bad faith could be that the insurance company could be responsible for all of the damages in a case and not just the policy limits, because that's what they're normally limited to. So, Fred, how long have you been doing bad faith work for?
Since 1992, so 32 years.
On one hand, I think bad faith is a dry, boring subject. I'm not really going to stick to any more about that, but I do want to share a couple of stories that happened with me and my firm in practice that illustrate that. One was a kid who got basically knocked down in his driveway by a car that was driven by a family friend who had $10,000 in insurance coverage. The boy got some really bad burn injuries to his skin and ended up with just bad scarring and hypertrophic scarring, which is real puffy, nasty scarring. The insurance company never paid the $10,000 limits, and my partner called Fred. And Fred, you have a great memory. Tell our listeners how much you were able to extract from the insurance company because of their own bad faith.
We got $750,000, I think, after we had done an agreed judgment for $750,000. So we recovered 100 cents on the dollar.
So they saw your name and they knew who you are. The insurance companies definitely know who you are. You're the guy they don't want to hear from, but they do. And another example, real quick, without getting in too much into the details, is my own personal experience when I was practicing. And a man came to me. His wife had been in a car crash, had been a passenger, and unfortunately she was killed. And the driver only had $100,000 in insurance. And when the husband came to see me, he explained all these things to me, and I said to him, so did they offer you the $100,000 policy limits for the death of your wife and the mother of your children? And he said no. So being very well trained, because Fred has lawyers very well trained, I said, excuse me, sir. And I calmly walked out of the room, picked up the phone, called Fred and said, Fred, I got this guy, I got this death case, $100,000 they never paid. And at the end of your involvement in the case, I think that was $2.5 million that the insurance company paid.
Well, it was actually $2.75 million on a $100,000 policy. That was a very unusual case, and I've had the same thing happen a couple times since then, where the insurance policy covered injuries, but also covered property damage. And you remember what happened in that case is the collision had caused your client's car to ricochet onto a City of Hollywood light pole, which caused, I think, about $300 in damage to the light pole. And the insurance company wanted to pay that $300 for the light pole and deduct that from the $100,000 they owed to your client. That was the first time I'd had that issue, Russell, but I've had it since then. And that one was different because it was a collector car or an antique car.
I'm sitting here thinking, why does this happen? These are big, multi-billion-dollar insurance companies that have all the money in the world. Why do these things happen? And my take on it, based on my experience, is one of two things. Number one, they're just not paying attention, or they're disorganized, or deadlines go by and things fall through the cracks. Number two, they try to play games and try to get out of a claim cheap and save money, and that comes back to haunt them. Are those the two basic scenarios that you deal with in bad faith, Fred?
Let me explain for the listeners, first of all, the concept of bad faith, because the legislature and the insurance lobbyists have tried to make it a lot more complicated than it actually is. I always tell people bad faith is just insurance company malpractice. There are standards by which insurance companies are supposed to handle claims. They're supposed to protect their policyholder. That's why they bought liability insurance coverage. So what we have to prove is they failed to settle within the policy limits to protect their insured when they could have and should have. So that's what bad faith is all about. What I see, Russell, is insurance companies love to save money. And first of all, I don't want to demonize the entire insurance industry. As I've said in Tallahassee, when we're fighting bad faith reform and tort reform, bad faith happens in probably a fraction of 1% of the insurance claims. Over 99% of the time, the insurance companies get it right. But there are cases where they get it wrong in spectacular fashion. And I've never met an adjuster that I didn't like when I took their deposition. I think they're nice people. They're trying their best. They're working hard. But typically what happens is they're not properly trained and they have too many files because the insurance companies are trying to save money, which is really penny wise and pound foolish on the part of the insurance industry. But typically, I think sometimes things slip through the cracks. I just took a deposition of a claim supervisor last week, and she was supervising 5 different adjusters, each of whom had about 250 files, which means she's supervising 1,250 files. How in the world are you going to do that and not ever make a mistake? So the insurance companies, I think, they like to talk about plaintiff's attorneys setting them up. I think they set their employees up for failure by not giving them proper training and not giving them enough help.
Fred, one reason that I never liked to gamble or go to the casino when I practiced was because I felt the odds were better at the courthouse. I had control over the evidence. I had control over how I tried cases. I love to try cases. And you never know what the jury's going to do. And that thrill of gambling I would get. And sometimes when you run into a small insurance policy, and I know this sounds counterintuitive, we would hope that the insurance company does not pay, that they do screw it up. Because if that happens, or they just sit on the claim, or they just don't evaluate it correctly, because when that happens, then we could really hit a home run and hit them for multiples of the policy limits, either at trial or sometimes they pay before because they know what's coming. Is that a pretty common sentiment that you see among plaintiff's lawyer, hoping they don't pay, telling the client, hope and pray that they don't pay the policy limits because then we have a shot at even more?
Sure. Our ethical and legal obligation is to maximize the recovery for our clients. And as you said at the beginning, I do personal injury cases also. I don't advertise, so it's harder and harder to get those cases. I've done personal injury cases, substantial personal injury cases for 35 years as well. But there's a tension there, Russell, because we have to prove in the bad faith case that the case could have and should have settled. And insurance companies love to say that they got set up or they got tricked by a plaintiff's lawyer. And the truth of the matter is, when an insurance company fails to settle and acts in bad faith, they almost always set themselves up. If a plaintiff's attorney does anything that probably would not be kosher, they're probably going to lose that bad faith case. In fact, when I see that, I typically will turn down that bad faith case because I always tell people that a bad faith case is really like a morality play. The judge and or the jury decides who's the good guy, who's the bad guy. And if you, the plaintiff's attorney, are the bad guy, then you're probably going to lose that case. In fact, under the new bad faith reform that passed last March, one of the factors that can be considered now is whether the plaintiff or the plaintiff's attorney did not act in good faith with the insurance company in terms of setting deadlines, providing information, etc. So the best bad faith cases are still the cases where the insurance company just really disagrees on the value. They don't pay the policy limits, and they go over and they try the case, and the policyholder gets popped with a verdict for more than the policy limits.
And since my audience is both national and beyond in other countries, generally speaking, that last thing you said, is that how bad faith typically is defined? Aside from the legislature, that stuff's all in Florida, right?
Yeah, we've had common law bad faith in Florida since 1938. And not every state has bad faith law. In some states, it's considered a contract action, like in Florida. Some of the courts call it a tortious breach of contract, which really makes no sense to me, but that's what they call it. In some states, bad faith is a tort, and you might have different damages than you have in Florida because, for example, in states where you have bad faith based on a tort, you can recover pain and suffering, emotional distress, and traditional tort damages. But in states like Florida, where bad faith is considered a contract action, then you can't recover that. You can recover consequential damages, however. But no matter what state it is, typically bad faith is going to be a deviation from the standards by which insurance companies are supposed to handle claims.
Fred, in the broadest sense, what you're telling us is some states have bad faith, others don't. So in some states, if the insurance company wants to play games, not pay the claim properly, there's really nothing that can be done and the claimant gets screwed. In other states, they have a shot, depending on what the law is. And sometimes that shot means that the insurance company is on the hook for all of the money that ultimately a jury awards or that is agreed to by way of settlement. Is that accurate?
That is accurate. And Russell, you also have to look not only at just the plaintiff and the plaintiff's attorney, not just the injured party. You also have to look at the insurance company customer, who we call the policyholder or the insured. In those states where there's no bad faith law, if the attorney decides to go ahead and go to trial on that case because it's a smaller policy, let's say the attorney thinks the case is worth $1 million and there's only $100,000 in coverage, then in those states, the attorney will go get that $1 million verdict, get a final judgment against that policyholder who only has a $100,000 policy, and they have to go bankrupt or they have to do something, but they're going to have a large judgment against them. In states like Florida, where we have bad faith law, the law recognizes that the bad actor there was really the insurance company and not getting the case settled. So the insurance company has to pay it off. It's a constant fight. The insurance industry hates bad faith law, as you might suspect. I would say it's the minority of the states that have bad faith law, though. I could tell you that.
But you are no friend of the insurance companies. In fact, your face is probably on some dartboards in some executive offices for some of these companies, right?
I didn't know that we could curse on your podcast until I listened to your podcast with Dan Santinello this morning. But I will tell you real quickly a funny story. A buddy of mine does a lot of work for a very large insurance company. And we had a case that went to the Florida Supreme Court called Harvey versus Geico, came out of the Florida Supreme Court in 2018, which really reestablished what bad faith law is in Florida. And so, is it okay if I say a curse word, Russell?
Go ahead. I can always edit it out if it's too extreme.
So, that's the same word you used this morning, or that I heard this morning. But anyway, my buddy went up to Atlanta to meet with them and talk about the Harvey case and some other cases. And the guy for the insurance company said, "Is that fucking Cunningham again?" And so I guess that's my name at this particular insurance company, is fucking Cunningham, which I wear as a badge of honor. But Russell, I never make it personal. I'm sorry that some insurance companies don't properly do their jobs. They're very good at accepting your money. In fact, if you're a little bit late with your money, they're going to send you a letter or two. They're going to fine you to get their money. But sometimes they're not as good at holding up their end of the bargain. And I have no problem with making them pay when they really, what they do is they injure their customer, they injure their policyholder. And they have the highest duty that the law recognizes. It's a fiduciary duty. It's the same duty a bank has with your money. It's the same duty a legal guardian has to award. So it's the highest duty recognized by law. And everybody knows the deal from day one. The insurance company knows they're going to take your money, they're going to sell you a policy, and they're supposed to protect you. That's why people buy liability insurance. So I have no problem with making them pay when they don't enforce their end of the bargain.
So that's a roundabout way of saying that all of the insurance companies hate you.
I really don't think that's true, Russell, because I never make it personal. And I think I've actually had some insurance people say to me, I'm glad you're on the case instead of somebody else. And I know they intend that as a compliment. And I think that's just because they know that I'm going to be reasonable. I'm not going to rub anybody's nose in a mistake. We all make mistakes.
My take on that, as my father used to put it, is they're simply keeping a civil tongue up your ass because you have the claim. They don't want to get hammered, and they still want to get away with as little as they can. Is it true that insurance adjusters, at least on liability claims, are bonused based on how much money they save the company from what they're given to try to settle it? Isn't that what it's all about, trying to save money from the what's reserved on a claim? Isn't that their
Sure.
mentality?
Yeah, I can't speak for the whole industry, Russell. I know there are some insurance companies that do that, and you can have a lot of fun with that when you find out they're doing that. Obviously, they typically try to resist discovery of that type of information. They will claim that it's proprietary, they'll claim that it's a trade secret because they don't want people to know that. Yeah, a lot of insurance companies do that. And you mentioned gambling, Russell. That's the cardinal sin for an insurance company when they know they probably should settle a claim within the policy limits or for the policy limits and protect their policyholder. But they think, nah, we think we can save some money off the policy limits. And then when they get beat, when there's a large judgment for more than the policy limits, I don't really know why they even fight those because what I always say is you can't have heads I win, tails you lose. It's just if I go to Las Vegas, the house is going to win most of the time. Well, when you go to Vegas, as long as you haven't done anything illegal and you beat the house, they pay you because that's what they're supposed to do. They're not supposed to gamble with the interests of the insured. They're supposed to treat it like it's their own money, and they're not supposed to try to save money when it's not warranted.
Yeah, but what they're supposed to do and what they actually do often turns out to be two different things. Fred, I wanted to also ask you, I know that human beings with the title of claims manager or VP of claims, someone in the insurance company ultimately makes a decision on what they think a case is worth. That's how it's always been in the past. But I wanted to ask you about AI or artificial intelligence. I know insurance companies are playing around with algorithms and AI. And have you heard of any situations yet where AI is analyzing all the data, every case ever filed with similar facts or coverage or whatever the variables are, and spitting out a value instead of people? Is this one of the things, one of the technologies that's going to replace those decision makers, in your opinion?
I think it's coming if they're not using it already. Everybody in the PI world knows that Allstate used a program for years called Colossus. They probably still use it. It's just a massive database. And they put all this information to it, and then it spits out a value or a range of values. And that's how the adjusters decide how much they can offer on a case. I think it's really dangerous. I think a lot of times AI, at least now, cannot pick up or account for a lot of the nuances that a human being can factor into the equation. So I think it's coming, Russell. And if it's a way for insurance companies to save money by laying off human beings, I think it's definitely coming. And it's going to be a brave new world once that happens.
Yeah, they say that AI is not coming for your job, but people who know AI, they are coming for your job. And I think that's true in the insurance industry as well. Let me just ask you, Colossus, I know that was really before AI, but I know they were using that program. How has that served Allstate? Have you had any big pops against them for bad faith?
Allstate, in my experience, does a pretty darn good job. I've had cases against Allstate. They're a big volume carrier, and it's a perfect illustration of what I said earlier that probably less than 1% of claims turn into bad faith cases. I would bet if you could look at it empirically, it's substantially less than 1%. So I've had some cases where Allstate's done some things that kind of made me scratch my head, but generally speaking, I think they do a pretty good job.
I always think of personal injury claims as gambling, and you always have that chance at the super jackpot if the carrier does not tender the limits. And that's why some lawyers tell their clients, you better hope and pray that they don't pay, because if they do, that's what you're stuck with. And
Well,
if they mess it up, you could get a lot more.
I heard my friend Dan Santinello talking about the nuclear verdicts. And I always tell people, I had this conversation with a lawyer last week who thought the insurance company would settle the case and they decided not to. And I said, every huge verdict is the result of a bad decision by an insurance company. So you should thank them. And when you think about it, Russell, you think about the fact that every case we try is being tried for one reason. It's being tried because the insurance company thinks they're going to beat you. They think that they're going to beat whatever offer they gave you. They think they're going to beat whatever demand you've made. And it's pretty remarkable to me. I think it's a real testament to my brothers and sisters in the trial bar that we win a large percentage of those cases when they think they're going to beat us. And I hope Dan listens to this because I think a lot of times it's like a game of cat and mouse. The defense has their research institute. We do our research. We share information. I think one of the advantages the plaintiff's bar has, Russell, is we share information a lot more freely than the defense bar does. And I think it's because they're understandably paranoid about losing business to another law firm. I'm in an organization called the International Academy of Trial Lawyers, and a number of my colleagues from Florida are in that group as well. And I've had lawyers from California and Texas come up to me and say, what is it about you Florida lawyers? You guys seem to really like each other. I said, we don't just each other, we love each other. We're like brothers and sisters because we've been through so many legislative fights together, so many tort reform battles. I think that's a huge advantage the plaintiff's bar has over the defense bar.
When
Yes.
you talk about the trial bar, you're certainly not talking about all personal injury lawyers. It's widely known, and the insurance companies and the defense firms actually keep analytics on this, which firms really do try cases and which firms don't, which firms work cases up for trial versus which firms only want to settle. Do you see that in your work when it gets to your desk about
Absolutely.
the underlying lawyer?
Absolutely. I've read some very interesting comments about friends of mine, mostly positive, some negative. But the insurance companies definitely look at that. And one of the sad things about advertising, Russell, I don't want to go on a rant either way on advertising. I work with a lot of advertising attorneys. I've chosen not to do it. But one of the sad things is with the restrictions that are in place, it's very hard for attorneys to differentiate themselves. And it's hard for the public to know through advertising that one lawyer is objectively better than another lawyer. And so I think members of the public get hurt because some lawyers are just not as good as others. And that's not unique to the legal profession. That's how it is with doctors, CPAs, auto mechanics, whatever. Some are better than others. But the Florida bar, with its restrictions, I think, has made it so that you can't really come out and say we're better than those lawyers. You can get board certified, which to me doesn't mean that much. When virtually everybody's board certified, it doesn't really mean that much anymore.
Let's keep it on the national level. On the national level, my take on all of this is that, first of all, the insurance companies definitely know which lawyers will go to trial and which lawyers will never go to trial. And as to the ones who never go to trial, they get what I call the Rodney Dangerfield treatment. They don't respect them.
Should.
They don't get enough. And why should they ever pay the policy limits if they know the guy's going to take the money and settle anyway? So I think a lot of them hold out for that, knowing and understanding who they're dealing with.
Absolutely, which is what they should do. And look, I've said to some insurance people, I don't know why you ever settle a case with so and so. You should try every case against that firm. Now, and I'll tell you, Russell, I don't know if you heard about this. Allstate did this maybe 20 years ago. I think it was in the Fort Pierce area, where they just decided we're not going to settle any cases with any plaintiffs' firms up here for a year. Let's just see what it does to settlement value. And what it did was it drove the average settlement value way down because what they found, which they probably suspected, is that a lot of attorneys don't want to try cases. And what I wish would happen, Russell, is I wish that the lawyers that don't want to try cases would do the right thing for their client and refer those cases and let them be tried if they need to be tried. Now, look, you also have to acknowledge that there is some risk in trying cases, but the best plaintiffs' lawyers win an overwhelming majority of the cases they try. And there's a reason for that. Yeah, I think clearly insurance companies know their opponent, and I think that's exactly what they should do. Just like we know which defense lawyers are more likely to try a case, which defense lawyers are better in trial than other defense lawyers. So it works both ways.
What troubles me about the Allstate experiment, if you want to call it that, this experiment by this company that refers to themselves as the good hands people, is that a lot, if not most of those claimants were probably good people with real claims, legitimate claims. And now Allstate, as a business decision, says we're not going to settle any of these cases and we're going to see what happens or whatever they did. So it sounds to me like as collateral damage, a lot of these claimants really got screwed by the good hands people. Isn't that what happened?
They probably got screwed by the attorneys they picked to represent them. How can you blame Allstate? They're running a business. Are you still clinging to the delusion that insurance companies really care about injured parties? Because I don't think they do. They're running a business, Russell. I say to people all the time, go to any major city, just about every arena, every baseball stadium, every football stadium is named after an insurance company or a bank. There's a reason for that.
Yeah, they're not paying you. They're putting their name on the stadium.
They're running a business. And so I can't quarrel with that. That's their prerogative to do it that way, as long as they're not running afoul of any insurance regulations in that particular state. But look, I think it's smart in a way to find out who's willing to try cases and who's not. Why should you pay somebody top dollar if they're never going to go try a case?
And despite that cold reality, I know it's still true. I was just talking to someone today about this who mentioned that they had an insurance claim. They didn't think they were treated fairly, and they really took offense at that because they had that company for 20 or 30 years, and they were really disappointed. To which my response was, they couldn't care less about you. You're a number. You start out as a policy number, and then you end up as a claim number. And sometimes there's not even a check number that results, and then you really get screwed.
But let me clarify what I meant, Russell. I don't mean to say that every insurance company is soulless and doesn't care at all about people. I do think, based on my 35 years of doing this, that there are some companies that tend to do a better job of being more compassionate, but there are some that don't. And I think a lot of times it's a corporate mentality. But you're exactly right. You're a claim number. And I tell people that all the time. When we're talking about settling a case, we all know that every negotiation comes down to leverage, right? I always tell my clients, what leverage do you think you're going to have against State Farm, Geico, Allstate, Progressive? If they lose your case, if they get popped, whatever they pay, they're just going to pass it on to their customers anyway.
And claim it's an anomaly or something.
You're never going to have financial leverage over one of these monolithic insurance companies. So take that out of the equation. Settle the case if you think it's a fair settlement, but if you don't, then go to trial. Those are essentially your options, right?
Yeah, absolutely. And plaintiffs' lawyers are gamblers. They take a lot of risks. And yesterday, you shared with me what I consider the ultimate story of lawyers taking gambles. What happened, if you could share with our listeners the story about when you were a young lawyer and you went with your boss, who became your partner, to one of these conferences when the tobacco litigation back 20, 25 years ago was starting up. So I know you went to some meetings. There were a lot of heavy hitters there. Tell our listeners what the proposition was for these cases, for law firms, plaintiffs' law firms, to get involved. So tell us about that, tell us about the risk, and then get to the payoff.
Sure. So this was, I believe, 30 years ago. I believe it was in 1994. I was practicing for 2 years at the time with a lawyer named Richard Slauson, and I practiced with Richard Slauson until the end of 2014. And he was invited to the introductory meeting of what was going to become the tobacco team in Florida. And the genesis of that was that Fred Levin from Pensacola, may he rest in peace, and Ron Motley from Charleston, South Carolina, may he rest in peace, came up with this idea of suing the tobacco companies under a subrogation theory for all of the medical expenses that Medicaid and Medicare had to pay because of people's conditions related to smoking.
Time out. They came up with this idea that why not go after the tobacco companies to try to recover all the money, all the Medicaid money, all the public assistance benefits that have been paid out by states as a result of smoking, which they knew was addictive and they knew was addicting people, and they weren't doing a damn thing about because they were making too much money. Does that summarize the basis for bringing these claims?
Pretty much. The pitch was essentially, it was given by Joe Rice, who was at the Ness Motley firm in Charleston. There are a lot of heavy hitters. There was Shelley Schlesinger, who was at Shelley's office in particular, Bob Montgomery, Chris Searcy, Mike Mayer from Orlando. I don't want to leave anybody out, but it was a really impressive group. And as a young lawyer, I was sitting there very wide-eyed, and what they said essentially was, look, here's the deal. We're putting together this team. Nobody has ever recovered a penny from the tobacco industry. Russell, you probably remember, you were in law school around the same time I was. There was a case called Chipalone, which went to the Florida Supreme Court, the U.S. Supreme Court. So nobody's ever made a dime from tobacco. We have a statute now. We don't have any documents. It's probably going to cost $100,000 a year. This could take 5 years. This could take 20 years. If we're successful, everybody that joins us will be wealthy beyond your wildest dreams. If we're unsuccessful, a number of people in this room might go bankrupt. And the reason I thought that was so interesting is because when the money did come in 1997, there was a great public outcry. In fact, even the governor, Lawton Chiles, who wanted the tobacco team, wanted to reduce their fees because I think each firm got $200 million in fees, which offended a lot of people.
Excuse me. Did you say $200 million in fees to these firms?
Yes, each firm got about $200 million. And unfortunately, my firm was not in that case for a multitude of reasons. But in any event, a lot of people got upset, but they have no idea of the risk that was taken. If you saw the movie The Insider, which was about Jeffrey Wigand, who was a scientist who was doing work for the tobacco industry, and he finally had serious problems with his conscience and just decided that he had to become a whistleblower. Then there was a paralegal at Brown and Williamson, I think in Louisville, who stole some documents that were extremely damaging to the tobacco company. So none of those things had happened yet. So these law firms, 10 law firms, signed on to this case, knowing that they could become phenomenally wealthy. But if you played the odds at that point, Russell, especially with no documents and no whistleblower yet.
So no evidence, basically.
The odds were against them. And so what they did is they got the case resolved in 1997. So only 3 years later, they got the case resolved and everybody became phenomenally wealthy. I saw some of my friends in the Bahamas this weekend who were on the team, and I thought about the fact that they were probably 50 years old when that happened. They took a huge risk.
And their boats were a lot bigger than your boat. True?
I think most of them flew there in private planes. They weren't dumb enough to fight the rough seas to get there like we did. But in any event, I think that's a great story that illustrates what plaintiffs' attorneys do. Our business model should not make much sense to anybody who's not a lawyer. We take ridiculous gambles. And Russell, the whole key to this practice is choosing the right cases. And if you're somebody like me, I think you were the same way, that you want to try to help everybody, but you can't, because if you take the wrong cases with the wrong clients, you can end up going bankrupt. I've known some attorneys that have gone bankrupt, and it's just because they probably were not selecting the right cases.
Or maybe they selected the wrong jury. But fundamentally, the contingency fee system goes like this. The client comes in, doesn't matter if they're the wealthiest or the poorest person in the world. If the lawyer likes the case, they take it. Why do they get 33 or 40%? because they're putting their time and they're putting their money and they're putting everything on the line, knowing that if they don't get anything, they don't get anything back. However, the upside is potential big gain, big verdict, big recovery, big
What I
fee.
tell people, what I tell non-lawyers all the time, Russell, when they want to know how it works, is I say, look, there are cases on which we lose our rear ends. There are cases where we lose a little bit of money. There are cases where we break even. Then there are cases where we make a little bit of money. And then there are some cases where we make a lot of money. I'll give you a great example. During the pandemic, I panicked because I knew that bad faith was really going to slow down, because obviously doing bad faith work depends upon people either getting verdicts at trial or having trial dates where we can get these cases settled. That wasn't happening. So I knew bad faith was going to slow down. I didn't know exactly how bad it was going to be, but I took a couple commercial contingency cases. And one looked like a really simple case. And boy, was I wrong. We tried it in March, tried it last month, and we won. We brought in co-counsel because it was a dispute over a finder's fee. For our client had helped a guy find somebody to buy his business for $240 million when the guy thought it was worth 100 to 150 million. And then the guy didn't want to pay my guy and wouldn't pay my guy. So I thought it looked like a pretty simple misrepresentation case. I was really wrong because they raised a lot of securities type defenses. So I brought in co-counsel. Adam Rabin and Lauren Johnson in West Palm Beach are phenomenal lawyers. They have about 2,500 hours in the case, which I tell people, if you worked 50 hours a week, that's basically a year working on nothing but that case. Our firm has between 2,000 and 2,500 hours in the case. Okay, so we started on that case in November of 21. So it took about 2.5 years. Now it's going to go on appeal, and we haven't seen a dime. And we may not see a dime for a couple of years. If you're not well capitalized, if you don't have the resources for those types of cases, those are the kind of cases that can bankrupt a firm, because that case took over my law firm, or at least my practice team, in 2022. It was almost all we worked on for the entire year. And it was just ridiculous. So you have to be really careful in what we do.
I'm surprised you took on a commercial case at all. And they're so different. And let me just ask you this, looking back, was the juice worth the squeeze? Are you glad you took the case?
It will be on that case. We have a fee shifting statute. And Russell, I always love learning. One of the things that I always say is, after 35 years, I don't learn something new every day, but I swear it seems every week I learn something I didn't know before. So I love that. It confirmed my belief that if you're a good lawyer, if you know what to do in a courtroom, you can try any kind of case. I did nothing to help with the jury instructions. They were ridiculous. We had 14 questions on the verdict form, but we knew how to try the case, and the themes were a lot like trying a bad faith case. It was a greedy defendant who didn't want to pay but should have. I don't regret taking it. I also took on a case against Cigna up in Connecticut when they stopped paying medical labs for services that they had been paying for a period of time. They were trying to cut costs on a national level. They figured they were paying too much money to medical labs for doing blood and urine testing. And that case was brought to me, and we jumped in on that case. We're going to mediate it later this month, but again, we have hundreds of hours in that case. What I learned is when you're going to venture outside your usual practice area, there's a learning curve involved. And I was not naive enough to think that wouldn't be the case, but I probably underestimated the length of the learning curve.
So the moral of the story is stay in your lane unless it seems like something you could really knock out of the park.
You can't stay in your lane if the legislature destroys your road. Okay, so the legislature is trying to. And so when you have an existential threat to your practice, as I told my partner Greg Yaffa this 10 years ago, I said, Greg, the legislature hates bad faith. The Florida Supreme Court, the current Florida Supreme Court, hates bad faith. You're young enough where you can retool your practice. And even though I became board certified before I ever tried a bad faith case, my marketing efforts for PI were really largely unsuccessful, mainly because I'm so identified with bad faith. So it's a double edged sword. It's a good problem to have that people associate me with bad faith. But at the same time, if something happens to bad faith, which it has, then you have to be ready to move on to other things, which I've done.
But it's still true in the law that the riches are in the niches. And this is a niche that you've done well at. You're certainly very well known at. And you're a necessary evil a lot of times for lawyers when there's really no other alternative and their clients are getting mistreated by insurance companies. True?
That was always my goal in life, Russell, was to be a necessary evil. So thank you for recognizing that.
So I learned a little bit of, speaking about learning something, I learned a little bit about your background when I first met you, and then when we were speaking in our pregame call before today's podcast. You've described yourself as half Chinese and half redneck who grew up in North Carolina. And you told me that your partner is basically a wasp from South Florida. So you seem to have a lot of those bases covered culturally, right? You went to University of North Carolina in Chapel Hill?
I did.
And someone who you went to college with turned out to be very famous, Michael Jordan. Can you just tell us briefly about your interactions with Michael Jordan at UNC Chapel Hill? And this was obviously before he got drafted into the NBA.
Sure. We were both members of the class of 1985, and this is obviously before Al Gore invented the internet. My freshman year, 1981, 1982. I don't want to reinforce any stereotypes, but I was an Asian kid who loved video games and was pretty good at video games. They had video games, they had video arcades, and the big games were, for me, were Asteroids, Galaga, and Pac-Man. And so there was an arcade in Chapel Hill where I spent a lot of time when I should have been in study hall. But in any event, I remember back then I was always an avid basketball fan. So I would follow magazines or newspapers that would come out that would talk about recruiting. And so I knew who Michael Jordan was. But I remember he came into this place that was called the Pump House, which was an arcade in Chapel Hill. And I was playing Asteroids and he wanted to play. And so we started playing, and I could play for an hour on one quarter. And so we started playing, and it was hilarious because he was just a really nice young man from Wilmington, North Carolina, real country boy. And we would play Asteroids, and he would stick his tongue out when he was playing. And when I would beat him, he would want to play again because he was so competitive. And same thing, he was better than I was at Pac-Man. I was never that into Pac-Man, but Galaga and Asteroids, he didn't win many of those. And we had a little bit of a friendship, but it was basically one semester, because then second semester, the ACC basketball season started, then the NCAA tournament started. And then after that, I didn't see him too much anymore. I don't think he could go out in public as readily as he used to. But super nice guy. It's just one of those quirks. I was in Chapel Hill at the same time he was. And now his house is about a mile from my office. I see him out on the town sometimes, but I would never expect him to remember me.
Did he hook you up with basketball tickets at least when he hit the big time? He didn't?
No.
But the one hookup you do have for tickets is Larry the Cable Guy, who I understand you're also personally friends with. True?
Yeah, that's a bizarre thing because it's no secret. His real name is Dan Whitney. He's from Nebraska. He was working at a hotel here in West Palm Beach and went to King's Academy for school. And there was a comedy club in West Palm Beach called the Comedy Corner, which drew a ton of national acts in the late 80s and early 90s. I saw everybody there. And I got out of law school in 88. I was living in some pretty cheap housing in West Palm Beach, and Dan lived in an apartment complex right next door. And we had a mutual friend named Dave Zide, who we'd hang out together all the time. And so we'd go to the Comedy Corner, and he would have made it big even if he never came up with that character, because he's just one of the funniest people you've ever met. He called himself the freight train of comedy. And he started doing this bit about, hey, you ever had this guy come to your house? And it was like a 3-minute bit about a cable guy coming to your house. And so I was one of the people that told him, it's just not that funny, man. Keep doing what you're doing. So that shows why I'm not a talent agent for comedians, but He's a really funny guy. He's a really good person. He's much more politically conservative than I am now, but we still have a lot of fun talking.
Is he still doing shows? Does he tour around the country?
He does.
All right. I'll call you before he shows up in South Florida again because I love the guy, and I expect you to hook me up with some good tickets.
Like, he's one of the funniest people you'd ever meet naturally, and he hasn't changed, even though he's made more money than God. He's a very charitable guy, very nice person.
Good. In fact, that's the whole reason I invited you on the show. I want backstage passes to see Larry the Cable Guy.
I'll see what I can do, Russell.
Thank you. So, Fred, I want to thank you for appearing on our podcast. Not necessarily the most exciting area of the law of bad faith, but it sure gets really exciting when a carrier is in bad faith and you're shooting for the stars as a lawyer. So,
when you recover for somebody $30 million on $1 million policy, that's pretty exciting for the client and for the referring attorney. Not that exciting for the insurance industry, but yeah, look, I love it. I tell people all the time, I get to help my clients. I get to help my friends that refer me the cases. I get to help their client. And I get to stick it to an insurance company that's probably abused a lot of people. So I think it's exciting. I think it's a lot of fun.
It is pretty exciting. I've changed my mind on that. But thank you so much for joining us.
One last thing, Russell. You're pretty excited when I called you and told you that they were paying $2.75 million on a 100 policy. In fact, you said something to me that showed your excitement that I can't repeat. But so you were pretty excited back then. You've become jaded since then. I think you made so much money that you become jaded.
If that's your perception, let's go with that, and that's fine and well. Fred, I'd like to have you live in the studio sometime. I want to put together some panels. Maybe I could have you and someone on the other side debating some topic that's of interest, and I could be the referee to make sure you guys don't kill each other. So thank you very much for appearing on this episode. I really appreciate it, and I'll see you again soon. That's a wrap for today's episode of the Interesting Lawyers Podcast. Thank you for joining us. And Fred Cunningham, thanks again. Appreciate it, and we'll see you next time.